the other thing I would add is I would contact State Fair Hearings Office and maybe even submit a letter to the presiding judge, because every State Fair Hearings Office has a presiding judge. There's a judge that presides over certain areas in California, so there are a number of presiding judges.
Okay.
I'll let you know. Okay, that's recording, and let me get to Facebook in just a second. Here we go.
All right.
Hi.
So we're live.
Yeah, we are live. I'm trying to get it. I'm just making sure really quickly before I start that it's actually recording on Facebook. I think it is. Okay. Hi, everyone. I am Gloria Perez-Stewart. Thank you so much for joining us. Looks like, as I'm doing this, I want to welcome everyone who is joining us today. And I apologize, I'm still trying to get my moderator in here. Jenna, so my name is Gloria Perez-Stewart of GPS Law Office here in Los Angeles, and I am a mom of a son with disabilities, a son with autism, and he's 21. And I have here with me today Jenna, who is also an attorney up in Sacramento. And Jenna, do you want to introduce everybody while I'm fixing the stuff in the background? Can you introduce yourself?
Certainly. So my name is Jenna Campbell, Jennifer T. Campbell, attorney at law in Sacramento, California. And I am also the mother of two sons with autism, ages 27 and 29. So we're in a slightly different place on the timeline than Gloria is. But we're all trying to manage those issues of making sure that our kids are taken care of and they're protected, and we can do what we need to do for them. So I've been practicing in the area of probate and conservatorship and estate planning and special needs trusts for approximately the last 13 years.
Okay. All right, great. So let me go back to my intro. I'm having trouble with our moderator. Hopefully Kristen will be able, she's here, but she doesn't have some access. So to all the attendees, just to let you know, we will send out the handouts, anything that we're talking about today. I was trying to get the chat option to open up so that I could send that out to you. We'll figure that out in just a second. But my name is Gloria Perez-Stewart again. And so I'm a lawyer, but I'm also a former community organizer. And that's sort of how I approach most things, especially with the law. I've served on the board of COPA. I've served on the board of NAPCE, both special ed organizations, national special ed organizations. And I've served as state commissioner for the state of California's advisory board on special education. So we're here today to talk about what happens when our kids turn 18. So there are a number of things that that parents come to us and ask questions about. And one of the things that was really discussed is housing. We've talked about school. Let me get into school actually very quickly. School. IEPs are mandated to address transition at to adulthood at age 16. Some states have even younger ages, just so you know, but the federal law is at age 18. Now, for transition purposes, that can be part of a special IEP meeting or part of a standard IEP meeting, but the most important thing is that it has to start with the transition assessment. And that has two parts. The ITP, individual transition plan, has two parts, and those are both with goals and with activities. It should address things like life skills, vocational training, job trials. I don't know, Jenna, do you remember anything from your IEP process from your sons?
Well, what I really call is most of our transition planning was the transition from the school district into essentially that adult extra time period for the disabled kids from 18 to 22. That was the biggest focus of the transition plan when they were 16, 17, was looking at those programming options. And most other issues were kind of delayed until that age 22 transition, when they were leaving the school district and moving into day programs or other services.
So that'll look different. I know that you and I both had children who were on the alternate curriculum, right? So Right. So that looks different. So typically a child has to be educated, at least here, until age 22. And so that's what's why Jenna's sort of bringing up the fact that sometimes you'll have a child who's on an IEP and who may turn 18, and, you know, but is still possibly in school for several more months. Maybe they are on the gen ed curriculum, and there's some sort of things that come up with parents in terms of how to access their educational records. If your child lacks capacity, there are certainly some options that you can have with that. Did you have that issue, Jenna, or had you already at that point at age 18 done conservatorship for your children?
So actually, I'm ashamed to say we were a little behind the curve, so we weren't right there at age 18. My older son is very limited verbal, and so of course he expressed no objection to us having information, so the school district continued to share information. My younger son is higher functioning, more verbal, and he would happily sign their form where they pointed to so that information could be released to me and I could continue to manage his IEP meetings until we did get that conservatorship finalized.
So have you heard any kind of, I've heard certainly horror stories with parents who've come to me and said, oh, you know, my son's 18 and now the school has made him sign, had a meeting without me, because he's 18 technically, so they can, and it's had a meeting without me and he signed this document. Now I don't know what to do. Have you had that sort of thing happen?
I have been very lucky that I have not had that experience. There was never an IEP meeting that was without me. I also have had very good, and again, I know sometimes this comes down to luck, dealing with either your regional center or your school district or the school site itself. I've been very lucky in that I've been always very much kept in the loop by the teachers so that type of thing did not happen. Mm-hmm. But that is a huge risk. It is a huge risk once they turn 18 that those things can happen if you don't have any authority.
And this is why we wanted to bring this subject up, because ideally parents are discussing these sort of transition topics for your child who has disabilities at age, I mean, ideally you want to say toddlerhood, but let's be realistic. Ideally, right, you're planning way ahead, but you're thinking about this maybe age 15, I'm assuming age 15, 16-ish, so that you can sort of think about these sort of life care plans. And today we're talking, this is a very general discussion. I want to be very clear to parents. This is a general discussion of the considerations that you parents need to make. Essentially, you have to assist your child in developing a very broad life care plan that does have, now we're both lawyers, but we're both moms. So these life care plans that you're talking about with your child have legal components, but there's also a lot of other sort of personal, social, financial components that aren't necessarily legal. But these are the things that you need to be thinking about. Now, the life care planning should include, it can and should include an assessment of the supports that your child will need in adulthood, similar to the IEP process. Your child has always had to have an individualized plan. And as they enter adulthood, it's similar. You're going to look at your child's needs, your child's wants, your child's desires, and your child's capabilities in determining that life care plan. And you'll need to look at those supports. You'll also need to identify public benefits for which they are eligible. You'll need to think about a financial plan and Jenna, I don't think you're a financial planner. I know I'm not.
No, I'm not a financial planner.
We do have some people that we certainly refer out to, but these are sort of considerations for you. A financial plan for supplementing those publicly provided services. Now, unless you have, you know, you're a multimillionaire, I think most parents that at least come to me are doing a mix. We're all doing a mix of public benefits and private sort of services, private things that we can provide for our children if it's possible. Yes. The other thing you'll need to think about is including a special needs trust, and that's only if means tested government benefits are required. Every child is different. So if your child does require, say, Social Security that's means tested, which means that they're looking at their income and their capabilities, then yes, you would require a special needs trust. You'll have to consider if a guardianship or powers of attorney need to be included in that. Are they able to make their decisions independently? And finally, one of the things, I don't know if you do this, Jenna, but it's a letter of intent to your future caregivers and your providers, sort of saying the basics of how your values and how you want your child to be raised. Or I wouldn't say raised because they're 18, how you want your child to live. Jenna, do you have anything to say about that?
Yes, that is something that is very important to think about, and actually to rethink about periodically, because our kids have such a variety of abilities,
Yeah.
and capacities and capabilities, and those are constantly developing. And so kind of reviewing what your plan looks like just on that big picture, that can constantly be changing and evolving. And when that happens, that may be time to be looking at the estate plan you have in place, talking to your financial advisor regarding the way that those services and private supports get funded. So yeah, it's something that you need to think about, you need to document, you need to discuss with those people that are going to be there to back you up, and you need to keep thinking about it and keep discussing it.
Okay, so let's get into, I talked a little bit about school and what your ITP, what your individualized transition plan should include. Now, post-high school options. We do have people on this webinar who are from different states. Now, this is going to be primarily California specific, but generally, there are state-sponsored vocational rehabilitation services. You have some community colleges that do things like, let's see, I know that there's some community colleges that support IEPs, so that's interesting. It depends, again, that depends on your child's independence level and their needs and what the IEP says, which is why it's really important to advocate appropriately at that IEP level. The other thing are private supported college programs, and I don't have much experience with those, Jenna may, but Shepherd's College, I know of St. Louis National University, CLE, I believe. So there are different sort of private supported college programs as well. Mm-hmm. And finally, life skills transition programs. Those are more residential programs. Regardless of which program, though, that you're looking at for your child post-high school, the focus needs to be on independence and realistic employment skills and, of course, their vocational training. And we're going to go into housing now. This is a fun topic for a lot of people. Fun, sort of
stressful. Terrifying.
Stressful. This is the one thing that parents, this is the biggest topic I've seen in terms of why, what people ask, and how they do it. And I've seen it in different states. So that's very interesting. But where will your child live? Where do you know? Is it going to be at home? Are they staying put? What are the considerations for that? Considerations if they're staying in the family home, number one, is it going into a trust? I mean, because you may have the intent. Well, actually, I'm making a very big assumption there. I need to stop because I'm assuming that the family home is owned by the parent. If they're, if we're talking about a rental property, then that's something completely different. And that's something that maybe that you will need to sort of look at different options for your child. But I'm speaking of a family that owns a family home, is thinking that the child with disabilities after, many years from now will remain in that particular home. What do you need for that? Well, Jenna can speak to this a lot more than I can, but cost of maintenance, who's going to respond in an emergency, caregiver reliability. That's a big one for particularly me. My son is 21. We purchased the house next door to my home, as hopefully with the intent of him living there independently one day with roommates. He's 21, doesn't want to leave, but that's a whole other story. That's a whole other story. My son while he has step brothers, he didn't grow up with his step brothers, so that's been sort of where I have to think about as somebody who grew up without siblings. Who's going to be the caregiver? what happens? Are there caregiver rooms? Are there places? Is there going to be a night caregiver? You're thinking of a 24-hour shift for someone. You're thinking of 8-hour shifts. Jenna, do you want to talk about that?
So yes, there's a lot of considerations, when you're thinking about where will my child live after 18, and how does that impact the whole family.
Mm-hmm.
Gloria has one son with autism.
Yeah.
I have 4 children. So I have 4 children, 2 with autism, 1 with some other issues, and 1 neurotypical. And so all families have different components, different makeups, different issues and concerns. And so sometimes it's a complex plan with lots of moving parts as far as where will my child live. And again, as I mentioned before, these are evolving plans that change over time. Some of our kids have behavioral issues that make it difficult for them to transition or to have their routines altered. So a lot of these things you're kind of considering, how do we work through all these different pieces and these different components? Is it family members who are basically providing care and assistance? Is it a supported living sort of option where we find out the supports, bring those in, and we monitor them? And just like I said, it's that evolving process. And those are the caregiving issues are probably going to be the most stressful, I think, for parents. I know that's the one I'm most concerned about as a parent. Currently, my children live in my home. My plan is for them to stay there. My plan is also for me to move out so that I am not there their entire life, so that we can monitor the situation of, let's bring in supports, let's bring in roommates, let's see how it works, let's fix it, so that when I'm gone, I know it's in place and it's working properly.
What are the considerations, though, that a parent, when they're doing the special needs trust and putting the family home in a special needs trust, Jenna, what are those considerations that they need to make? I know, I mean, we've spoken about this, but, you know, parents come to me and they say, who's going to pay the property taxes? I don't know, you know, so what do parents come to you with?
Yes, it's really, how do I make sure that my child gets to stay in my home? And again, the number one thing, if you own your home and you want your child to remain in that home, doing a special needs trust as part of your estate plan is going to be vital. So hopefully everyone has at least a basic understanding of estate planning. One of the most powerful estate planning tools for your typical family is just what's called a revocable living trust. And it lets you name that person who's going to make decisions when you're gone and manage the property. The biggest advantage of this revocable living trust is it's very flexible and it doesn't go through probate. So we've minimized a lot of cost, time, and expense and stress. Now, how distributions out of that trust after your death depend on what instructions and rules you put in that trust. A special needs trust is a set of rules. It's a set of rules that says my successor trustee is going to manage this property and spend this money in a way that makes sure my child's public means tested benefits are not impaired. That's what, whenever we talk about special needs trust, that's really what it comes down to. So for supplemental security income, the basic benefit that is provided by the federal government for disabled persons, it's a minimal amount. California, with the state component, it's somewhere around $960. It is not an amount that's going to make it easy for anyone who relies on that alone a livable life. Generally, I mean, you can't even get an apartment for that, hardly anywhere in California. So, which is why most of us parents are very concerned about where our children are going to be living, especially when we're not here, because we know that money is not going very far. So the Special Needs Trust allows us to protect that money, to make sure that that money is available for their food and housing expenses. So if we have a family home that we're going to keep our child in, then we say this family home is going to go into this Special Needs Trust so that my child lives there their entire life. Now, one of the things that the language in a Special Needs Trust does, it says all of these assets are here for the benefit of my disabled child, but my disabled child doesn't own anything. And that's how they get to keep their public benefits, because they don't own those things. They're not resources. So they don't count against them. So hopefully there's some funds that are also available to go into that Special Needs Trust, and those funds are going to pay the property taxes and the maintenance. And for most people with special needs, with a disability that are really relying on the SSI, if there's an option for roommates, so costs can be shared, that's going to make a huge difference. But in general, that house stays in that trust, and it's there for the benefit of your child, and somebody is managing it. Someone's making sure it's taken care of. Somebody's making sure that those property-related expenses get paid for. And then at the death of your child with disabilities, that trust is going to say, and at that point, this is what we do with the property, whether it's going to grandchildren, family members, siblings of the disabled child, whatever the instructions are. And like I said, it's very flexible. It's a very flexible tool. Okay. But it is very important for anyone with a special needs child to have an estate plan that provides those special needs trust provisions for their disabled child so that they don't end up losing all their benefits. The other thing that a lot of families do and is say, okay, well, I'm going to give everything to my other child. Oh. The other child is going to take care of my disabled child.
I've seen some horror stories on this one. Yes.
And we all hope that's what's going to happen, but there's no requirements.
Well, that's ideal. I mean, right. These are children who probably grew up together, and you, of course, and there's, what you're failing to realize or failing to think about or plan ahead about is that child may also get married. That child may also lose assets in a divorce. There's so many variables there. That child may get sick. Go ahead, Jenna.
Exactly.
That child may have their own child with disabilities. You're
right. And so a special needs trust, make sure that your disabled child is protected. Make sure that someone has authority to do what they need to do. But you know that those assets are going to take care of that special needs child. So it's very important. It's something that every parent should be looking at, taking care of their estate planning.
Okay. So I'm going to go into, so this is a staying in family home. Those are the considerations that we were talking about in terms of staying. So the family home, the cost for that can be variable. That just really depends. Is your home paid for? Is it not paid for? Will life insurance at the death of a parent pay for the remaining mortgage? There's so many variables there. So there's really not a way to put a strict cost on that. But those are the things you'll have to think about in terms of utilities. You'll also have to think about transportation for your child. Where do you live? Will your child be able to access their existing services? And usually they will be able to if it's their family home. Now, the other option would be a private supported residence. And this varies in different states. But those are cottage communities. I know that there are some autism communities that are really impressive. Private group homes, those are also pretty expensive in terms of, we're looking at maybe $3,500 to $10,000 a month. I think there's some of those, right, Jenna?
Wow. I haven't looked into that. Now I know why.
Yeah, that's not even a consideration. Yeah, there's not. It can't happen. So yes. So, and then of course we've got public supported residence, and a public supported residence would be something like a group home, board and care home, supported apartment. Those are the lowest cost options, but considerations for those would be the location, the quality. Do they get a choice of a roommate, or do they even get their own room, or things like that. And the cost to individualize their care. Maybe that is the best option for your family, but then you still want to supplement. You still want there to be a plan for your child to receive other, and that would again go into the special needs planning, special needs trust, right, Jenna?
Yes.
Okay. All right. So I wanted to bring this up only because I am a divorced parent. So, oh well, Jenna, you are too. I'm sorry.
I am a divorced parent as well.
I apologize. So this is interesting because when I originally, as part of my divorce decree, and this varies from parent to parent, from divorce decree to divorce decree, but my situation was such that my child was receiving child support for life, and I want to say most states do offer. I think there are state laws that that have an option for a parent in a divorce to ask for the court to consider child support for life, and that would be just forever because the child needs that sort of support. But when your child turns 18, there's another consideration in that. If you are divorced, if your divorce decree does say child support for life, the other consideration is that the Social Security Administration will count those child support payments as countable unearned income to your adult disabled child. They'll subtract all but $20 of that income from their SSI check, and that's why it's very important to irrevocably, what we lawyers call irrevocably assign through a court order those child support payments to possibly, and Jenna can talk a little bit more about this, a D4A, as a first party special needs trust, so that they don't count towards that adult disabled child's income. I don't know, Jenna, if you've had that experience, if you've had people come to you for that, I don't know if you have.
I actually have not had to do that yet, but it is an option for those people who have child support and have another parent who's actually paying child support to manage those funds. Because yes, the courts can continue that child support order as long as that child needs support. And so yes, we can. So what Gloria was talking about, the D4, we're talking about a special needs trust that has the assets of the beneficiary themselves. Mm-hmm. It's what we call a first party special needs trust. It's a little different than the trust a parent creates for a child, which is what we call a third-party special needs trust. And that's just based on who owns the assets that went into the trust. If the trust beneficiary themselves owns those assets, it's a first party. And we can create a first-party special needs trust, which will also protect those assets from being counted for as resources or income against that beneficiary. And so the main difference between the first party special needs trust and the third party special needs trust is upon the death of the special needs trust beneficiary, if those assets originally belonged to somebody else, the parents, any other family member, so the third party, those assets can continue on to whoever that trust creator chose.
It's sort of like, can I just jump in? It's sort of like, this is the money, this is a gift, but I get to say, if something happens to this beneficiary, the person I'm giving it to, I get to say who gets it later. That's
exactly, Gloria. With a first party special needs trust, that same language is there, but in between the death and those funds being moved on to the next person, the state gets to come in and say, we spent money for this person and now we want to get paid back. It's called a payback provision. And so that has to be in that special needs trust. But that's the only price you actually pay to get the benefit of not having those funds count against your child, the beneficiary. So it's a great tool. And for those families that for some reason their disabled child has funds, whether it's ongoing child support or life insurance proceeds or a personal injury settlement is another place where a disabled person may end up with funds suddenly that we need to protect their benefits. So some families may have the first party special needs trust and the third party special needs trust.
Mhm.
So for those families, my number one piece of advice, when you spend money out of the first party special needs trust first. That way you're minimizing whatever goes back to the state.
Okay. So, and there, I was trying to think of something that happened recently. It was a client that came in, and every one of these is variable. And I really want to stress that to parents. Every one of these situations is variable because let's say your child turns 18 and you are retired. You know, we have different age parents that come in that talk to us all the time. So if you're, you know, then we're looking at different SSDI benefits, you know, or we're looking at different benefits if your child ever worked. I'm sorry, when I'm speaking of SSDI, if your child ever worked, if your child ever had a part-time job, there are different ways to maximize some of these public benefits, and everything is variable. We are getting a little bit into the nitty-gritty though of special needs planning, and I kind of want to back up a little bit because this was going to be very general. But yeah, another consideration, if you are a divorced parent, you do have a divorce decree that states that you're receiving child support for life. That's something that you need to consider if you do want your child to receive SSI. And I'm going to give a personal story because I think it's important for you guys to know us both, you know, as moms, right? What I did, because that was happening, and I was in a different situation when my son turned 18, I made the decision with my ex-husband to modify my divorce decree. And that for us worked well because he was already investing in the home for my son, you know, for the future. And for us, that made more sense because we wanted our son to go ahead and qualify for SSI on his own income. So they're not looking at me anymore. They're not looking at me or my husband. I'm remarried. So they're not looking at me. They're not looking at my income anymore, strictly on his income. And that was that for us, that was the easier way. Now the other families are doing completely different things, but that was a sort of a trust thing for us, and it worked. It was, you know, important for us. So now my son qualifies, of course, for Section 8, for Social Security, for SSI, Medicaid, which is Medi-Cal in California. Okay, I'm going to go on to, now we're looking, ABLE accounts. This is a fun one. So in late 2014, Congress passed the ABLE Act, which is Achieving a Better Life Experience Act. And it authorized states to create tax-free savings accounts that could be used to pay for disability-related expenses without affecting the person with disabilities' means-tested government programs. But only people who had a disability that occurred before age 26 can hold one of those ABLE accounts. So just, that's sort of a thing right there. Only one ABLE account can be established per person, but there's no limitation to the number of individuals who can contribute to that one account. So that's interesting in certain terms of if you have maybe older grandparents, people that want to contribute to the, maybe they said, we wanted them to go to college. We were going to pay for, you know, we wanted to give money to this. You have an ABLE account that they can donate to. I don't want to say donate. I don't think
Contribute.
Yes, contribute. That they can contribute to, that will be able to go to use. You can use that for your child, and it doesn't affect their government benefits. The ABLE, but it can't exceed 100,000. Then we're getting into another territory. Jenna.
Yes. Yes, so it will protect assets up to the $100,000. The other limit on it is that, as Gloria said, as many people can contribute to that account, but the maximum contribution is one annual gift exclusion per year, which is approximately $15,000. So if you can't have two grandparents give $15,000. But you can have two grandparents each give half of that $15,000. So it's a great option. It's a great option that is newer. So even though it was enacted like 6 years ago, it's taken quite a while for the states to get those programs up and running. And California's program has only been like up and running in the past like year. But it's a great option. It avoids a lot of the first party special needs trusts and the costs of creating those for smaller sums of money. Yeah, I had the experience of one of my clients' sons, his hobby, he would go gamble, and he won a car. And a car.
I love the story.
Yeah, and he won a car. And he didn't need a car. So it's like, oh, okay. Now a car is exempt as a, for SSI and for Medi-Cal. You can own a car, but he didn't need a car. So in that case, what we ended up doing was we created a special needs trust for him, a first party special needs trust established by his parents. He put the car in the special needs trust. His parents bought the car from the special needs trust, so they got the nice brand new car, and he had this money. But we needed to protect that money from, it was a $20,000 car. So that would have,
that's super creative, that.
Yeah. So he would have lost, benefits, didn't lose any benefits. Now that cost, there's a cost to creating those estate planning documents and things like that. If at the time there had been an ABLE account, they could have just bought the car and put the money in an ABLE account. So that is a really wonderful tool that we have available to us now for our kids. And it works really just like the 529 college plans. Yes. You put the money in, and it can be used for certain purposes. And as long as it's used for that, it's protected under the program rules. So it's really, and luckily the disability related expenses is really broad. So it's a great option, and it's probably saving a lot of families a lot of money from having to do, some advanced estate planning documents that were necessary before, but now we can avoid. So that's a great option.
And I've had a few people that have set them up themselves very easily. So that's something that parents can do on their own. Simply.
You just find the bank that offers the program, and then you go in and you open the account. It's fantastic.
My husband always laughs at me because I always say, "Oh, I love you, past Gloria," and he's like, "Who are you talking to?" And I'm a planner. If I don't know if anybody knows that about me, but you should. I have planners everywhere, and it's hilarious because I'll find something. I'll be in a different position. I'll be in a different situation. I'll be in a different car, maybe different, whatever. And I'll say, "Oh, I need this," and I open it up, and there's my little bag with my little organ. And so I'm always saying, "I love you, past Gloria." And what we want today to do is to make you say that same thing. You need to think about, these are things you can do on your own. And I really want to stress that to parents. Some of these things are very simple. And it's necessary, and go, so that the future you is saying, "Oh, I'm so glad that I at least set that up." Because my son won a car. No, just
yeah, exactly.
The gambling. I love that. Okay. So now we're going to get into decision making, because we only have a few minutes left for today, because this is a two-part series. I should have said that at the beginning, and I apologize. This is a two-part series. We were going into generalities today, and next week, April 14th, we're going to discuss a little bit more in terms of decision making, but we are going to go into decision making and considerations for parents now. So when our children turn 18, we've been used to being parent advocates. You know that. I know all of you out there. I know how you are. I know how frustrating it is. I know the feelings. I know the emotions. Trust me when I tell you that I still, after certain meetings of my own son, despite having done this for, special ed advocacy for 20 years and whatever, I put myself to bed because it is exhausting. It's emotional, all of that. We have to think really before age 18, we're now shifting roles. Our child is now becoming of legal age. What does that mean? What happens there? There are different determinations for your child. There are different alternatives for your child. And one is an alternative to guardianship that is really, I'm from Texas, and I have been fascinated to look at the differences with different states. Because California has the Lanterman Act. So I'm speaking to different states too. But California has the Lanterman Act, which is a state-specific act that goes into self-determination for people with disabilities here in the state. It's beautiful, no joke. From coming from someone who from another state, it is beautiful, and it is probably one of the best, I personally think, in the country. But what is interesting is that there is another model which is called supported decision making. California does, and Kristen, I don't know if you can put up some of the supported decision-making links in the chat box for people. Supported decision-making is an alternative to guardianship that I ask parents when they come to me for limited conservatorship, which we will get into later. But when parents come to me, one of the first things I ask is, have you done something different? Have you tried anything different? Before you make a leap to what your child needs, let's see what we've done. And there's an alternative, and this is an alternative to guardianship that uses friends, family members, and professionals to help the person with disabilities understand the situations and choices they face so that they make their own decisions. And questions that you need to ask yourself, parents, is, does your child have the capacity to understand situations and the choices they face on a day-to-day basis? In terms of a check, I had a parent come to me that whose child did not, and this was in another state actually, but whose child did not have any sort of guardianship or anything, but had handed over, signed over their check. This was way back in the days when you had checks. People don't do that anymore. So these are things, if someone comes to your child and asks them, hey, sign this, hey, do this, are they able to understand that? Do they have that capacity? And one of the first steps to thinking about that is supported decision making. Kristen just put the link there. You can click on that link, and I think that's very important for parents because every state is different in terms of what they're doing for supported decision making. And one of the fascinations for me as a lawyer here now is looking at the state my home state, and realizing which has many limitations for people with disabilities, and California does not. California is where the disability rights movement began. And what is fascinating to me is that we don't have as much in terms of supported decision-making here in the state of California. Now, there's a supported decision-making agreement that you come up with. It's more informal. You're identifying people in your child's community, sort of their natural supports, and figuring out, hey, can you help so-and-so my child make this decision about managing money, about working, about taking care of themselves. Those are the sort of things that supported decision-making addresses. And I always try to push parents to try that first before they go into other more limiting alternatives. I'll say that. And I don't know, Jenna, if you have anything to say about that. Oh, another reference though for parents who are interested in exploring supported decision making would be the ARC, ARC of California, the ARC in your state. I'm speaking to parents in California now. Jenna, did you?
So yes, and those are the important things. And that is sort of the lead into limited conservatorships, which are specifically designed for people with developmental disabilities, recognizing that our kids may be able to make decisions, may be able to get assistance and manage decision-making in certain areas, even if they can't manage it in another area. So the limited conservatorship narrowly focuses on getting authority in those areas where they really need the help, but leaving the power and the authority with them for those areas that they're not at risk if they're responsible for. And so that's an important thought process for parents as their kids are reaching 18. Again, looking at those natural supports and the natural ability of their children and who they're listening to, and looking at those areas where, okay, my child is at risk here, so this is what we need to address. And again, so it's really taking a look at, if my child is presented with this type of decision, one of the main ones that is of most concern to parents after being taken advantage of financially and physically is medical decision making.
Oh yes.
Medical decision making is a really hard area because you're trying to figure out if your child is actually capable of giving informed consent. And this, I'd say, is the most difficult area for most of our kids. And so it's kind of trying to figure that out. Can they really go through that thought process? Or is this something they need help with? And again, it's looking at those types of decisions for, can they choose a home? Can they find a home? Can they understand a lease for an apartment? So it's kind of looking through those different decision areas for education, for residents, for medical care, and really trying to see, do they understand this? Are they at risk here if someone else is not in charge of making the decision? Because we want our kids to have as much independence as they can. We want our kids to be as, self-fulfilled as possible. We only want to make decisions in those areas where they really can't manage it, and it's not safe for them to have it under their control. So it's an important discussion with your child and those natural supports, and just paying attention to the situation. The good thing is that we in California do have this limited conservatorship process that does recognize that persons with developmental disabilities it's not a cookie cutter world.
No.
You can have a child that cannot make medical decisions, but they are perfectly capable of making educational decisions, of handling their mail, of choosing friends, all of those things. So and it also puts an affirmative duty on the conservator that's appointed to encourage independence, encourage decision making by the disabled person as much as possible. That is an affirmative duty, that they are to exercise their powers in a way that fosters that adult's independence and independent decision making, and respects their opinions and their wants and desires, even in those areas where the conservator is exercising authority.
So we are at the end of our time, but I want to just bring up, thank you, Robert, for saying that. I'm glad you brought up supported decision making, as most attorneys don't. You're right, and I've seen that. And I think that's a difference, Robert, in that we are moms or parents of kids with disabilities, and we look at obviously every client and every situation in that manner. You have to look at it through that lens of how you would want your child, what you wanted for your child, and the considerations to be taken. Yeah, that's very important. So next Friday, the 14th, we're going to bring up substituted decision making, and we're going to get into the real more intense things in terms of substituted decision making. If you've tried supported decision making and maybe it's not an option for your child, or maybe your child needs more support or more help, what are you going to do then? And that's Jenna, can you go into a few of the topics that we're going to discuss? Maybe
so we'll be really going into more detail about those limited conservatorships
and how they can do them themselves. They can if they want. It's hard, but you can.
Yes. And the 7 powers. There are only 7 powers that a limited conservator can have. So we'll talk about those powers, and then the process of getting that conservatorship established.
Yeah, and I think that'll be a little bit more too in the California history, because I love the California history in terms of the disability justice movement. So thank you all for tuning in. You should get handouts of this later. Catch us next week, Friday, August 14th, where we'll get into the limited conservatorships, how if you want to do them on your own, you can. And if your child requires one, I want to always stress that. Thank you so much. And in the chat, you have information on how to contact us. And I think that's it. We'll see you next Friday. Thank you for tuning in.